Well, good morning. Good morning, everyone.
Good morning.
Good morning, and welcome to another one of our famous, often imitated, never duplicated Google Hangout sessions. Here to talk to you again about important things you need to know, workplace rights. And I'm Lior Samfiru. Along with me is my colleague, Lumi Punja.
Hi.
And we try to do these every few weeks to give you a bit of just a very quick rundown on a few things that you have to know, important things that if you have a job, had a job, thinking of working, maybe you're an employer, things that you need to know that are going to help you. You know, these are relevant things. These are things, we don't pick obscure topics here, and we hope that people enjoy them. And certainly if you do have suggestions, ideas, thoughts, comments, good or bad, feel free to contact us. Let us know your thoughts. Let us know how we can make these even better. We want to provide you with information that you can use that's useful to you. Now, I think we've done that today. I think we've picked a topic today that's extremely important, and it's one that we see every day. And what we're going to be trying to do today is we're going to try to debunk or clarify some of the biggest misconceptions out there with respect to termination of employment, severance, and losing your job. The reason why we started these Google Hangouts in the first place, the reason why our firm hosts a radio show is simply because there's so many misconceptions out there, half-truths, things that people believe that are not true, that we felt compelled to do something about it. We felt compelled to say something and to tell people how things really are. And it's because of these misconceptions that people often walk away from their legal entitlements. People believe that if I lose my job, I only get this or this happens. And not knowing that that may not be true, they'll accept things that are not right. They'll accept severance packages that are inadequate, losing tens of thousands of dollars. So we're going to run down some of those biggest misconceptions today. We're going to try to tell you why they're there, how they arose, and then of course tell you the actual truth, tell you what the real facts, what the real law is. So hopefully you'll find this educational. These are things that we see, we deal with every single day. And again, feel free to contact us after with questions and comments. Now, topic then, clearing up the biggest misconceptions, debunking those misconceptions as relates to termination and severance. I'm going to start us off then today. Probably one of the biggest misconceptions, certainly one of the most common one, is that you can't be let go unless there's a good reason. A lot of people believe that, hey, I did nothing wrong, I can't be let go. That there's something wrong with that. And if I am let go, even though I did nothing wrong, that would be a wrongful dismissal. So let's clarify that. That is not true. That is a misconception. The reality, the truth, the law is that an employee generally can be let go at any time for any reason, as long as proper compensation and severance is paid. An employer does not have to have a good reason. An employer does not have to have a good reason. An employer simply has to provide the compensation and severance that is owed. There's an example that I like to use because it makes the point, and that is the employer can say to the employee, you drive a blue car. We decided we only like people that drive red cars, so we're going to let you go. Now, obviously that's silly. No employer, I think, would ever do that. But from a legal standpoint, that would be fine. A lot of people call us very upset, and understandably so, that they lost their jobs, they did nothing wrong, no one told them there was an issue. Maybe they felt that their employer simply wanted to hire their friend, and that's why they were let go. No, from an ethical standpoint, even from a business standpoint, that may be wrong. But from a legal standpoint, that is legal. That is allowed as long as severance is paid. Now, there's an exception to that, and that exception is an employee cannot be let go for discriminatory reasons. An employee cannot be let go because of their age, their ethnicity, their medical condition, their sexual orientation, pregnancy, etc. Those are illegal. But an employer can simply say, well, you know, I don't like you as much as Bob, so I'm going to let you go, as long as severance is paid. The big problem, of course, and what makes a case a wrongful dismissal is that severance is not paid properly, and most employers don't pay severance properly. The last thing I'll say about this topic is if an employer tries to let an employee go for cause, i.e. without any severance, for that there has to be a good reason. There has to be a great reason, in fact. An employer has to have to be able to show that the employee did something terrible, something horrible, to be able to let them go without severance. But as long as severance is paid, for the most part, the employer can let the employee go at any time and for any reason. That's a very important thing to remember. Lumi.
Yeah, I just wanted to say that these misconceptions apply amongst employees, but also amongst employers. We get calls from company representatives, and they seem to share the same type of misconceptions, and some confusion is definitely there, even amongst employers, even amongst some sophisticated employers. One of those misconceptions that I get that seems to apply to employers a lot is employers believe that if they don't have a large payroll, or if the employee had been with them for, let's say, less than 5 years, then no severance, no termination pay is owed. And of course, that's wrong at law. And whether we're dealing with a corner shop or with a large auto parts manufacturer in the GTA, the same rules apply. And so companies, again, large or small, cannot avoid their obligations to their employees, their departing employees, just by virtue of having low revenue or having a small payroll, or just by virtue of the employee having been with the company for a relatively short period of time. The termination entitlements are a function of three things, and we've repeated that numerous times during our discussions. So termination entitlements are a function of length of service, age, and the nature of the employee's position. And at the end of the day, it comes down to how long does it take that person to replace his or her job. And so that is the rule. And again, the characteristics of the company or minimal service for the employee are not relevant.
To emphasize that, I had a case, Lumi, just earlier this week. A lady contacted me, very nice lady. I had worked for 28 years for a very small accounting company. Either 3 or 4 employees, and they let her go. And they said, we don't have to pay you any severance because we're a small company, and that's, severance is just for big companies with big payrolls. And they gave her nothing after 28 years, and that, I don't think that company was trying to be bad. They believed that they were under that misconception. And now, of course, not only was she owed severance, after 28 years, she was owed as much as 2 years pay. So that's a huge distinction. That's an important misconception for everyone watching this today to understand. Size of payroll doesn't matter. The length of employment doesn't matter in the sense that you get severance even if you work for a few months. So that's important to understand that, and whether you work for as Lumi said, for a huge company or a tiny company, all other things being equal, your severance is actually going to be the same.
Right. We have a long list of topics. We'll try to get through as many as we can. Lior, do you want to do the next one?
Yeah. So the next one, one that man, we see every day, literally every single day, and that is people believe, employers and employees, that in the construction industry, if you work in the construction industry, there's no severance, so that the construction industry is some sort of a lawless environment. Well, no, that's not the case, and not a case at all. In fact, as Lumi said, the factors are age, position, and length of employment, not the industry that you work in. So if you work in the construction industry, not only do you get severance that's calculated in the exact same way as everyone else. Now, where does this misconception come from? Well, employees in the construction industry may have different minimum entitlements than employees that are not in the construction industry. The Employment Standards Act that sets minimum entitlements may not apply in the same way. But that's only relevant with respect to a person's minimum entitlements. Your full termination entitlements, what we call common law entitlements, are exactly the same. So, to simplify, whether you're working in the construction industry, or if you're working in manufacturing, hospitality, whatever it is, you get the same amount of severance. How many times have we seen people let go, working in construction, outdoors, indoors, whatever it is, let go on a moment's notice without any severance because the company believed legitimately, in the sense that they weren't trying to make it up, that they don't have to pay any severance. It's almost been like the Wild West. Well, let's clarify. Yes, 100% you get severance. You get the same amount of severance. The law applies to you in the same way. So if you work in the construction industry, if your friend, your neighbor work in the construction industry and lost their jobs, let them know. Tell them, yes, they get severance. And if the employer is not paying them their full severance, have them give us a call.
Absolutely. The next point I wanna cover is, we get this all the time, literally all the time, that there is some sort of a magic formula, very simple formula for calculating one's termination entitlements. And everybody has different numbers for that formula, but basically the idea is, the incorrect idea is that you get 1 week per year of service, or 2 weeks per year of service, or 5 weeks per year of service. And that couldn't be more far from the truth. The reality is that calculating someone's termination entitlements, as I said, is a function of 3 factors: length of service, age, and position. And it comes down to estimating how long it takes to replace a particular job under reasonable circumstances. And so, no, it's not 1 or 2 weeks per year of service. The length of the reasonable notice period varies based on a number of factors. We're able to determine that based on everybody's, each individual's circumstances. And so you need a lawyer to calculate your termination entitlements, or you can use the free severance calculator that our firm has developed, and that can give you a general sense of what your entitlements are. And again, that calculator looks at the relevant factors, but at the end of the day, you need a lawyer to take a wholesome view of your circumstances and estimate your entitlements appropriately.
Probably what Lumi just said, that misconception, probably the most important one we're going to touch on today. There's no rule of a week per year of service, 2 weeks per year of service, or any other number per year of service. It's not that simple. And to make the point, let me give you an example. You could be working at a company for 6 months, lose your job, and be entitled to 6 months severance. And so in that case, it could be a month per month of service. It's not that simple. It's based on those factors. So many people believe it's a week or 2 weeks. That may be relevant to someone's minimum entitlements, has nothing to do with the person's full entitlements. So please remember that.
I will add just something quickly here. It's actually a separate item on our list, but I feel like it fits in perfectly. So someone with very short service, for example, gets disproportionately high or disproportionately lengthy notice period, and a number of things play into it. Whether the person was induced, whether the person is let's say like in their, like an older individual. Another, like executive positions, again, are very difficult to replace. So the fact that you've been in a job for less than a year will not make it any easier to replace that job. And the law recognizes that. And as I said, for short service, the reasonable notice is disproportionately high.
Yeah, people believe, well, you know, you only work for a company for a short period of time. Maybe what are you going to get? A week's pay if you're lucky? Wrong. As Lumi said, you may actually get disproportionately more severance. You could have worked for a few months and get a few months severance. So that's an important misconception. So many people believe the wrong thing there. Now, moving on, one of my favorites, or favorite misconceptions, I should say, is the fact that people believe, again, wrongly, it's a misconception, that the Ministry of Labor, the Labor Board, can help individuals with respect to their entitlements and advise them with respect to entitlements. I'm not going to talk long about this. I did a whole session about that just a couple of weeks ago, so you can scroll on our website and find it. The bottom line is the Ministry of Labor or the Labor Board can only advise someone with respect to their minimum entitlements. So if you call the Ministry of Labor and you say, I've worked for 3 years, I lost my job, what am I owed? They're going to say 3 weeks pay, full stop. That is wrong. Those may be your minimum entitlements. Your full entitlements could be 6 months, could be 8 months, could even be 12 months, depending on the circumstances. So that's so important. And the reason it's so important is if you don't know that, you can call the Ministry of Labor and they say, well, 3 weeks is all I'm owed. My employer offered me 4 weeks pay. I guess I'm going to accept that, not knowing any better. And then in doing so and relying on the advice of the Ministry of Labor, you may lose tens of thousands of dollars that the law says you should have. So that's a misconception. The Ministry of Labor cannot help you if you lose your job in assessing your full entitlements.
I will move on to the next item, and that is that people believe that poor performance can be cause for termination without pay. Again, that's very wrong. The most relevant, I would say, and common example is people with very lengthy service being put on performance improvement plans by a new manager, for example. The employee gets very, very concerned, and it's natural, it's intuitive that they're concerned that they would lose their job for not performing at the standards expected of them. And no, that's not the case. As Lior started today, you can be let go. That's true. That applies across the board. You can be let go for any reason, performance being one of those reasons, but you do not lose your termination entitlements just because after, let's say, 15 years of service, somebody decides that you are no longer up to par.
Well, this is actually perfect because literally we just got a question here from Philip, who says, if an individual was wrongfully terminated from a job of 12 years, should he or she be entitled to severance? The company is standing by their decision as they have said they have cause. Well, obviously the real question is, why does the company feel it has cause? What did the person do? I can tell you this, obviously I don't know any more than what I just read. For the company to terminate someone for cause after 12 years, man, they really would have to show that the person did something terrible, something, not that they made a mistake. They may well have made a mistake. Maybe they did something wrong. Maybe they even did something quite wrong. That's still not necessarily going to be enough. It's very difficult to terminate someone for cause. It's the death penalty of the employment relationship. So you can only terminate someone for cause if you did something so bad, so wrong, so horrible, and that you can't be employed anymore. And even usually that means that you would have to show that, or the employer would have to show that they tried other discipline, they warned you, maybe suspended you, and at some point they'll just put up their hands and say, what more can we do? We have to let you go. Very difficult. In our experience, in the vast majority of cases, when an employer lets someone go, quote unquote, for cause, there isn't cause. They pulled the trigger well before they should. So Philip, whether it's you or maybe you're writing about a friend, have them call us. Let us assess the matter. It's easy, doesn't take us very long. And then we can tell you whether that's a wrongful dismissal or not, because after 12 years of employment, whoever this person is could easily be owed a year's pay, maybe more than that. We're talking about a lot of money and important entitlements. So thank you for the question, Philip. I'll be happy to speak to you or your friend off air if you'd like.
Again, without knowing Philip's circumstances, I would say, and let me know, Lior, if you agree, from what I've seen and from the cases I've read, it's theft, forgery, fraud, physical violence.
Yeah.
Those are examples where
those are the unforgivable sins.
Yeah, you can't remedy that. But beyond that, yeah.
Very difficult.
It's very, very difficult to establish cause.
Yeah, very difficult. Now, going along with our list of misconceptions, next one, man, it's a big one, and that is that an employer has a right to temporarily lay off an employee. So a lot of people believe, employers and employees, even some lawyers, by the way, believe that an employer has that right to lay off someone temporarily. So let's make it clear. No, that is not true. A temporary layoff is a termination. To clarify more accurately, if someone's been laid off temporarily, they have a choice. The choice is as follows. They can choose to accept the layoff and hope and wait, and maybe the employer calls them back, and they can go back if the employer calls them, or they could treat that as a termination right there and then and seek and get their full severance. Why is this a termination? Well, if I told you that your employer reduced your pay by 50%, I don't think anyone here listening would disagree. Well, wait a second, that can't be right. That can't be something that the employer is allowed to do, 50%. Well, what if I told you that your employer reduced your pay by 100%? Well, that's what a temporary layoff is. It's a reduction of pay by 100%. It's illegal. So a lot of employers believe that they can buy themselves time by laying someone off temporarily and then, let's deal with it 6-8 months down the road. No, you can't do that. There's really only two situations where a temporary layoff could be allowed. Number one is you signed an employment agreement that specifically gives the employer the power to lay you off temporarily, and most people have not signed anything like this. Or second, you let them get away with it in the past. So if the employer laid you off in the past temporarily, you accepted it and came back to work. By doing that, you may have created this precedent, this situation where now they have the right to do it again because they did it once. That's why it's so important to not necessarily do that, because if you were laid off once and you were going to be a good team player and you said, you know what, I'll come back to work even though I'm not happy. By doing that, by doing what seems to be reasonable, you've given them a right to do it again and again, and maybe next month it happens again, and next year it happens twice, and at that point, what do you do? So if you've been laid off temporarily, in many cases, most cases I would say, you're better off treating it as a termination and getting your full severance for months, hoping that you'll get called back. How do you pay for your mortgage? How do you pay for your bills if you're not working? So to clarify, no, there isn't a right to lay off someone temporarily. It is a termination. Lumi, let's do one more and then we'll wrap it up.
Absolutely. The one item that I want to mention today is some people believe that if they were wrongfully dismissed, one potential remedy, one potential solution to their legal problem is reinstatement. And that is wrong. In most cases, there are very few exceptions. And so in most cases, reinstatement is absolutely not an option. And the solution to the resolution to a wrongful dismissal matter is an adequate severance package, not reinstatement. Very rarely do employers take back terminated employees, and there is no legal mechanism to force the employer to take the employee back unless certain very, very strict requirements are met, and most individuals cannot meet those requirements. It's very my clients are very disappointed when they hear that the reinstatement is off the table once they receive the termination letter, but that's the reality, and so to believe otherwise is not realistic.
Yeah, a lot of people call us and really all they want is their job back. I've done nothing wrong. I've worked with this company for many, many years. I want my job back. Clearly, I should be allowed to have my job back if I did nothing wrong. And even though there's logic to that, it makes common sense. As Lumi said, that is not a remedy that the law provides in almost all cases. There is no legal mechanism to make the company take an employee back. So because of that, whenever someone loses their job, it's a question of compensation. It's a question of severance. And that's important to understand, that's how the law works. Now, we could continue with this list probably for the next hour. There's so many misconceptions. You know what, Lumi, maybe it's a good idea for us to come back to it at another session and speak about some other misconceptions that are out there, because we're really here to educate and inform. But again, if you have any questions, Philip just did ask us a question. You can use this form to ask us. You can contact us always. You have our contact information, hopefully. You can check out the severance calculator. It's available at severancepaycalculator.com. Visit our website at stlawyers.ca. Happy to talk. As you can say, we're not that bad at people, so we can always answer questions that you have. So that is it for us. Thank you very much, Lumi.
See you next time.
Thank you all. All the best. We'll talk to you soon.